students, welcome to Legacy Arts Academy. In today's video, we are going to discuss about recently cleared by Cabinet of India is the Data Protection Bill. So we are going to discuss about what are the major features of this bill and what are the criticism and concern associated with the Data Protection Bill. So first of all, to give you the brief background, 6 years almost after the Honorable Supreme Court of India had held privacy to be a fundamental right, the Centre has made a second attempt at framing legislation for the protection of data. Now, in this regard, the Digital Personal Data Protection Bill, year 2022, a draft of which was floated in the November last year, is expected to be tabled in this upcoming Parliament's monsoon session, which is going to begin on 20th of July. In this regard, the Union Cabinet has recently, just 2 days back, approved the draft bill that is related to the data protection laws, and some of the most contentious and the provisions that were criticized by the expert before and the flagged by experts also in the November draft have been retained in this particular bill. So we have to see that how the discussion takes shape in the parliament once the bill is introduced by the government. Now, if we talk about the overall data protection and related legislation, especially related to privacy in all across the world, we can say that India has legislation with regard to the electronic transactions related data. It has legislation with related to privacy and data protection that is in the pipeline. It has legislation related to legislation. However, as far as the consumer protection is concerned, India does not have any special or dedicated data protection bill. Similarly, if you look at the entire world map, the countries which you are seeing in the blue, including India, are those countries which are having some sort of legislation in these two issues, that is data protection and privacy, while countries which are in light blue, they are the ones which are having a draft legislation. Then the countries that are in yellow are those countries which are having no legislation in this regard. And these countries are very few in numbers. If you look at some countries in Africa, some countries in South America, then we have Afghanistan, Bangladesh. So barring few countries, almost we can say all the major countries in the world have dedicated legislation related to both data protection and the privacy. If you look at it from the numbers point of view, almost 71% of countries are having some sort of legislation. 9% of the countries are having draft legislation. 15% of countries do not have any legislation in this regard, and 5% of countries are such from where sufficient data has not been gathered. So what is the significance of such privacy law as is floated by the Government of India? Now, Digital Data Protection Bill of 2022 is believed to be a very crucial pillar in the overarching framework of technology regulations that the central government is building. Basically, it is a part of what we can call as, it is basically part of the other provisions as well, such as Digital India Bill, which is proposed successor to the IT Act, that is Information Technology Act, that was initiated that was basically formulated in year 2000 and later on amended in year 2008. And because the cybercrime and related areas, we can say technologies are continuously getting upgraded, continuously evolving. Thus, many experts also had suggested that IT Act currently is toothless in its current form to fight the cybercrime, cyber terrorism, cyber espionage in the modern context. And that is why Digital India Bill is going to replace it. Similarly, we also have a draft bill, that is Indian Telecommunication Bill, that was also formulated in 2022 to basically control or regulate the telecommunication sector. And third approach the government is taking is regarding the formulation of policies for the non-personal data governance. So Digital Personal Data Protection Bill is one of the pillars of the overarching regulation, overarching framework for the technological regulations in the India. So what are the major features of this data protection bill? So first of all, if we try to understand that this bill will apply over which kind of individuals, entities. So first of all, the bill and its regulations, its provisions will be applicable whenever there is a processing of personal data that is happening within the territory of India, as well as all those data that is being processed outside India as well, if the purpose of the processing of data is for offering certain goods or services or for profiling individuals who are based in India. So both within India and outside India, with some caveats, that will be the overall applicability of the bill. Now, this bill basically regulates the working of data fiduciaries. Data fiduciaries basically refer to those entities or individuals or organizations which are responsible in collecting and transmitting and sharing of the data related to the people. So basically, data fiduciaries have been given a stringent responsibility in this bill where they have to maintain the accuracy of data, keep the data secure in nature, and also delete it once the purpose of the data has been met. So that is the broad provisions related to data fiduciary. Third provision is related to voluntary undertaking provision. Now, in this regard, if any entity or organization has breached or has not followed the provisions of data protection bill, then these organizations by themselves can approach the data protection board, which will be established as per the bill, and thus taking the matter into cognizance, the data protection board can then decide to bar any kind of proceedings against the entity by accepting some sort of settlement fee as a penalty for violating the data protection bill's guideline. However, this will be undertaken on the case by case basis. If some organization or entity is basically involved in multiple what can I say multiple breach of the law, multiple breach of the act, then obviously the amount of penalty will be much more higher. And in this regard, the bill specifies penalty to be rupees 250 crore per instance. Now, what does this word term or term per instance means? Now, per instance term is mainly subjective in nature as per the government officials, and it can mean both a single instance of data breach by an entity or it can also account for the number of people that is impacted due to this data breach, and thus such incidences can be multiplied, each of these incidences can be multiplied by 250 crore to reach the actual penalty that this organization is responsible to pay back to the government. Now, though these are the very good points to make the data of people of India secure and the sensitive data especially, there are certain concerns as well that is associated with this bill. And the first concern is there has been wide-ranging exemptions that are provided to the government agencies, especially the central government and its agencies, where the bill clearly states that central government can exempt any instrumentality of the state. It can be any department, it can be any ministry, it can be any organization, agencies, from adhering to the provisions of the data protection bill on what account? So three accounts have been mentioned here. First, on the accounts of national security. That means if following or if adhering to the data protection bill and its provisions compromises the national security, then such instrumentality of the state can be can be exempted from adhering to the data protection bill's provision. Second, if it violates or basically make the relation with foreign government causes deterioration of relations with foreign government or impact adversely the relations with foreign government. And third, if it is essential for the maintenance of public order among other things, then exemptions can be made by the government of India. The second concern is related to the appointment and terms of service condition both for the chief executive and the members of data protection board, because the chief executive of the data protection board will be the board that is adjudicatory body that will deal with the privacy related grievances and dispute between two parties. The chief executive of this board will be directly appointed by the central government, and the terms of service condition will also be actually decided with the central government. Thus, if suppose when there is a dispute between two parties and if one party is the government itself, the neutrality and the impartiality of the data protection board can be questioned. The next concern is related to Right to Information Act, which is a revolutionary act passed in year 2004. So many experts believe that such passes of data protection bill and then gradually its transformation into an act can cause dilution of the RT Act. Now, how it can cause dilution of right RT Act? Because the personal data of the government functionaries is likely to be protected under this act, and thus it can become very, very difficult for these personal data of government functionary to be shared if the applicant is asking for such data through the medium of right to information. So these are the major concerns with the bill. However, significant changes also has been made between the November 2022 version and the recently produced version. The first such change is in the terms of the cross-border flow of data. In this regard, the cross-border data flows, especially to international jurisdiction, has been the approach of dealing such data has been changed from whitelisting to blacklisting approach. So what is whitelisting approach and what is blacklisting approach? So first of all, you talk about whitelisting approach. It basically refers to a situation where the central government can notify countries or territories where personal data of Indian citizens can be transferred. That means if government has listed 50 countries in this white data list, then only these 15 countries are where data can flow freely. And if someone want to transfer data to suppose any other 51st country, then it has to follow the due process, take permission of the government, and all these longer regulatory procedures were there. So this was much more stricter mechanism, we can say. This was much more difficult mechanism, and thus government has made it more moderate and shifted to blacklisting mechanism. Now, what is blacklisting mechanism? In this mechanism, government will basically put the countries into negative list or blacklist, and by default, all the data flow can happen to jurisdiction except the countries that are put into the negative list, that are put into the blacklist. That means you just have to see, suppose 15 countries are there that are put in the blacklist. So except these 15 countries, you can share, and we can say the concerned authorities, concerned entities, concerned organizations can share data without worrying about the impact of this decision on their what we can say company, and how the government will react. The other important change is which we can refer is to the matters of deemed concept. Now, deemed concept refers to a situation where if government departments are processing and transacting with any data, they will assume the consent to be present beforehand while processing this personal data on the grounds of national security and public interest, while same things will not be available, same leeway will not be available to the private entities. The consent will have to be taken specifically by private entities separately while processing of such information and sensitive data. So if you take a look at the data protection at the global level, an estimated 137 out of 194 countries have put in place legislation to secure the protection of data and privacy. And these countries are basically in Africa, 61%, Asia, 57% countries have data protection. And in LDC, total 48% of countries, that is 22 countries out of 46, have the data protection laws. Now, as far as the data protection laws are concerned, basically three models are there that are largely followed across the world. First is what we can refer as European Union model, that refers to GDPR, that is General Data Protection Rule. This General Data Protection Rule is most comprehensive data protection law for processing of personal data that is available in the entire world. Many critics also have called this GDPR or General Data Protection Rule as excessively stringent because it imposes many severe strict obligations on organizations and entities that are processing data. However, despite being so stringent in nature, the GDPR rule is considered as a very good example, very good template for most of the legislation that are drafted around the world in different countries. The second model is what is followed by United States. In the case of United States, the privacy protection is largely defined as the protection of liberty, or the term that is used is called as liberty protection, which is focused on the protection of individuals' personal space from the government. Now, if you look at the US model, this is considered to be a much more narrow in the focus because it enables collection of personal information as long as the individual is informed of such collection and use. And last we have is the China model, where China has basically implemented its personal information protection law in last year itself. And the Chinese data principle new right, it basically grants Chinese data principle new right as it seeks to prevent the misuse of the personal data. And now we have the India that is coming up with its data protection bill. So we have to wait and see to know about the detailed provisions of the bills once it is introduced into parliament. However, what we can say in the conclusion is that bill, once it is passed, once it becomes a law, will play a very crucial role in India's trade negotiations with the other nations, including UK, US, and European Union, and especially the regions which are basically following the general data protection rules, which are most exhaustive privacy law. Because whenever we are having any kind of trade negotiation, the matter basically comes and both regions, both countries come to a situation of impasse because the European Union countries do not consider India's current law to be stringent enough that can actually tackle the processing of the personal data and the other kind of data. So that is all about this particular video. I hope you understood about the salient features, concerns, and the impact that will have by the passage of the data protection bill. That is all for this video. If you like the video, please hit the like button, share it with your aspirants, as well as subscribe to our channel for more content. Thank you.